Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reisch. Thank you for joining us. If you haven't done so already, please hit that subscribe button. Hit that little bell so that you receive notifications when we go live or put up new content. And as always, leave us a comment below about what we discuss here today. First on the docket, Leticia Stauch. For those who do not recall, Miss Leticia Stauch is charged with the death of her stepson, Gannon Stauch. Really bad facts of the case, and you can look at our previous videos if you want to get into the specifics of it, because we've put up a timeline of those events. Now, Leticia Stauch, the issue of competency was raised by her attorneys. A first competency evaluation was conducted, and the doctors who evaluated Leticia Stauch said that she was, in fact, competent to proceed. Now, the defense then said, hey, judge, we don't like that evaluation. We want another evaluation done by basically another doctor because we don't think the first one really gave enough time to meet with Miss Leticia Stauch, even though it was something like 30 hours or something along those lines. Normally, these evaluations are meant to be done rather quickly. The defense already sought one continuance. Well, guess what? The defense is seeking another continuance, and that being for the fact that the doctor conducting the evaluation cannot get into the jail. The jail where Miss Leticia Stauch is being held, the El Paso County Criminal Justice Center, has had a COVID-19 outbreak going back to late October. Basically, to date, over 1,000 inmates and 147 staff members have tested positive. So when the doctor tries to get into the jail to meet with Ms. Stauch to perform the evaluation, the jail has said all visits are canceled until further notice. And needless to say, further notice has not been provided. Now the defense has filed a motion saying, Judge, our expert cannot get in and speak with Ms. Stauch, and therefore we need additional time. Obviously, the court cannot proceed until the second evaluation is done. So what is the court to do? Well, the matter was already set for a status conference on December 18th. At that status date, it is set for a 15-minute hearing to update the court on basically how much time is going to be needed so that this report can be completed. Understand, once competency is raised, until the court is satisfied and all the other evaluations have been done, and there will more than likely be a hearing where we'll have competing doctors, assuming the defense doctor will say Leticia Stauch is not competent. This could take a while to get resolved, but the court can't do anything until those issues are resolved. So December 18th, we'll find out exactly how much time the good doctor who's evaluating Miss Leticia Stauch will need to complete her evaluation. We'll let you know after the December 18th hearing. Now, we've had a lot of people that would qualify for the Parent of the Year award, and I say that facetiously. And obviously, we don't want to judge particular individuals. Perhaps they were at their wits' end, and this is what they thought was going to be the best thing for the child. But police in Mississippi have taken one suspect into custody after a toddler was abandoned at a Goodwill location with just a note and a change of clothes. The 2-year-old boy, who authorities did not identify by name, was left behind at a donation center. Authorities said the child was dropped off by a man wearing black jogging pants and a black cowboy hat who left the scene on foot. The toddler had with him a plastic grocery bag containing a note and some clothing, according to the police. Surveillance cameras in the areas captured images of the man and a woman who authorities believe were involved in the incident. The two were seen together in a red vehicle when the boy was abandoned. The one suspect that has been arrested came after a public appeal for information. The police wanted everybody to know that the child was in the care of the Child Protective Services and would remain there until they were going to be reunited with the family under the proper conditions. Once Goodwill became aware of the situation, they immediately contacted police. So I guess, like I said, we don't want to judge. Maybe there were circumstances where they thought this was their last resort. Maybe it could have been handled differently. Maybe there was some ill intent. We don't know. but it restores your faith in humanity that people came forward to identify the people that were involved, and apparently the child was well-nourished, cared for, and dressed appropriately for the weather. So I will be wanting to follow this story a little further to find out why this was done. Let me know if this destroys your faith in humanity, or if maybe it gives you a little glimmer of hope that there's still some good people out there looking out for others. Yes, that's right. First on the docket, Lori Vallow's attorney, Mark Means, is at it again. Now, he has gone so far now as to say that he has filed a motion to disqualify the prosecuting attorney and motion to extend time on motion to dismiss. Well, let me tell you, when you attempt to disqualify a prosecuting attorney for what is alleged in Mr. Means' motion, I'm telling you, you better have your facts lined up, because Mark Means, on behalf of Lori Vallow, has stated that he has received audio recordings between the prosecutor, special prosecutor, Mr. Robert Wood, and a material witness, allegedly Summer Shiflett, which is the biological sister of the defendant. Now, apparently this encounter occurred in October of 2020, and apparently there's a recording of it. You would think if you're going to do bad things, you're probably not going to record it. Needless to say, the recording clearly illustrates Mr. Wood's attempt to coerce, unduly influence, coach, and or intimidate said material witness in this case. In addition, there's an alleged audio recording of Mr. Wood interviewing another material witness, a woman by the name of Zumela Pastinas, also right about the same time as this other recording, October of 2020, discussing matters that supports the state's position of the case. Defendant asserts the following, and this is where it gets pretty bold. He is alleging that the prosecutorial misconduct violated the due process rights of the defendant's Idaho and U.S. Constitution's right to a fair and impartial jury. I'm not sure how that particularly happened. Next, that the prosecutor engaged in coercive, unduly influence, coaching, and intimidating tactics to manipulate a material witness in this case. Next, Mr. Means alleges that the prosecutor in this case violated the Idaho rules of professional conduct as well as the ABA rules by his actions, statements, and the like detailed on said audio tape. The prosecutor's misconduct could be construed under the witness tampering and witness intimidation statutes as criminal acts. The prosecutor's misconduct has made him a material and necessary witness in this criminal case. Further, the defense intends to file additional motions as it relates to the evidence and intends to subpoena the prosecutor as a witness to support these motions, future motions, and the trial itself. He further alleges that the prosecutor's misconduct has caused the potential for future civil directed at or involving Fremont County, Madison County, as well as the prosecutor and any other entities involved or associated with this misconduct. So I guess he's saying he's going to sue him too. And the prosecutor's misconduct has included concealing evidence in violation of Brady and the rules of Idaho criminal procedure. So the Mr. Means then moves in his prayer in the motion that the prosecutor be removed. So let's talk about this motion, okay? First, if you're going to accuse another attorney, let alone a prosecutor, of tampering with witnesses, engaging in criminal acts, I'm telling you, you better have your ducks in a row. You don't go around accusing people of ethical misconduct unless you're absolutely certain. And you know what? If you have such glaring proof of such misconduct, you better specifically articulate it in your motion. You don't use this overall veiled attempts. And let me tell you, if Mark Means is wrong about these allegations and the judge denies it, guess what? He could face his own ethical issues related to this. You don't go around throwing the big E word, ethics, unless you're absolutely certain, and you better put it in the motion. Mark Means also alleges that his client's due process rights have been somehow violated. Well, the matter was turned over in discovery. These audio recordings were turned over in discovery. So the prosecutor is complying with this. I'm sure there's going to be an explanation as to why they were not turned over earlier if that's what he is alleging. Now, just because a prosecutor interviews a witness, and most prosecutors usually take an investigator with them or that they record the recordings, but normally you have a witness. Why? Because then a prosecutor would in fact be a witness. That's why when I go talk to a witness in a case, I always take my investigator with me to take notes as to what was said. Otherwise, I could become a potential witness. And if you are a potential witness, you can't be on the case. So you always take a third party to record that. My guess is the prosecutor in this case, Mr. Wood, this is not his first rodeo, ladies and gentlemen. These recordings were probably done, and there was probably another witness there. So he's not going to be a witness. Now, if you think that the prosecutor was heavy-handed, telling somebody that we're going to call you as a witness, somehow thinks that you're intimidating them, guess what? You save that for cross-examination. What does Means think he's going to get by getting the prosecutor off? If you are going to file that motion, it better be a silver bullet, okay? Because when you go after the king, you better make sure you kill him. Otherwise, it's going to get ugly. I think this is going to get ugly for one person, Mark Means. I've expressed my concern about Mr. Means. Mr. Means filed a motion for a bond reduction argument early on in this case because he thought one of his calls was recorded and therefore he was entitled to have his client removed and released from custody. There was a hearing on that and Mark Means looked like a fool. I think Mark Means, and I will reserve judgment, but I'm just telling you, there's nothing in this motion that makes me think that the prosecutor needs to get off this case. Mark Means may want to contact ethics counsel and see how he may want to correct this because I think he's over the top. We'll see if Mr. Pryor files the same motion on behalf of Mr. Daybell. As of right now, nothing. And if this is where he's going with it, he's got a big, big problem. We'll see how things shake out. But like I said, I think Mark Means is in completely over his head. And when you go around making these allegations, you better be 100% right. And I'm just telling you, from this motion, it's not there. It's not there. Unless there's something egregious on that recording, and I'm going to bet, and I'm going to guess that it's not, Mark Means may be the one getting off the case because he's going to have to deal with attorney regulation. We'll see how things shake out. Let me know what you think. As you recall, yesterday we talked about the allegations made by Lori Vallow' attorney, Mark Means. He made a motion to disqualify the prosecuting attorney, and he also wanted additional time to extend the deadline, so that he could file a motion to dismiss. Now, these are some pretty bold allegations that Mr. Means made, and then Mr. Pryor, the attorney for Chad Daybell, filed basically a motion to join, which pretty much mirrored the motion filed by Mark Means. Now, as I stated yesterday, if you are going to go after the prosecutor, you better have a silver bullet. And the motion, I think, leaves a little to be desired, frankly, because there's no specificity. Some very bold, broad sweeping allegations are made regarding violating the rules of professional conduct. The prosecutor has made threats and intimidated and basically retaliating against witnesses, and that's violating everybody's due process rights for a fair trial. Now, you don't go accusing people of unethical conduct, particularly a district attorney of unethical conduct, unless you better have a smoking gun. And I'm telling you, you better have a smoking gun. Otherwise, the judge is going to crush somebody like you've never seen before. Well, the prosecutor in this particular case, Mr. Wood, has filed a response. He actually filed an affidavit in conjunction with the objection that was filed, not signed by Mr. Woods, but Troy Evans, who's a deputy special prosecutor for the Fremont County District Attorney's Office. And as you may recall, and I think I may have misstated. I woke up in the middle of the night thinking, did I misstate that? Because the defense stated they had just received these audio recordings of these material witnesses that were made in Arizona. Frankly, Mr. Means' motion is somewhat inarticulate in spots, and I thought it came through discovery. Well, it turns out these recordings were made by the attorney for these material witnesses, and they were turned over to the defense. In no way did the prosecutor have these tapes. It appears as though he also didn't know the tapes were made, and so how could he go and get them and turn them over to the defense? Simply not going to happen. So the prosecutor responds in his affidavit, stating that he's obviously the elected DA and that he's always acted in accordance with the Idaho rules of professional conduct and has strived to seek justice in this case while acting in accordance with his duty to protect the rights that he has to protect those of the defendants, both Chad and Lori Daybell. Now, he adamantly denies, Rob Wood adamantly denies that he coerced, put any undue influence, coach, or intimidate any witness or instructed a witness how to respond to any questions regarding law enforcement. In fact, the district attorney goes on and says all of these recordings that the defense references in their motion with a Summer Shiflett and a Zumela Pastanetis were all while they were present with their attorney, an attorney by the name of Gary Smith. Mr. Wood says that he never met with the two witnesses outside the company of their attorney, and the meeting with Ms. Shiflett took place on October 1st, and the meeting with Ms. Pastanetis took place on October 2nd. Both meetings took place at the Chandler, Arizona Police Department, apparently at their request. And when I mean at their request, Ms. Smith, Ms. Shiflett, and Ms. Pastanetis came about as a result of Ms. Pastanetis reaching out to law enforcement and Mr. Wood's office through her attorney, Mr. Smith. The meeting among Mr. Wood, Mr. Smith, Mrs. Shiflett, and Ms. Pastanetis were introductory in nature and not investigative in any way. The meeting took place before the investigative meeting with law enforcement, and Mr. Wood did not sit in on the meeting with law enforcement. And he states that at no time did Mr. Smith, the attorney, make any objections to statements or questions by Mr. Wood. And after the introductory meeting, Mr. Smith accompanied his clients to interviews with law enforcement in which they actively participated of their own free will. At no time did Mr. Smith raise an objection or concern that Mr. Wood had coerced, unduly influenced, coached, intimidated, or instructed a witness how to respond to any questions. And then nearly 2.5 months have passed from this October meeting until now, wherein no objection was ever raised. And Mr. Smith, the attorney for the key witnesses, has never raised any concerns or objections about what occurred that day. Now, not only did Mr. Smith not object during the initial meeting with his clients, they met with law enforcement a second time a few weeks later. Now, Mr. Wood did not record the meeting. I think that is key. All right. Prosecutors have a duty to turn over information that's in their possession, or if they know about it and it could be exculpatory, they should go get it. But if you didn't know it was being recorded, how could you know that you had to go get it from somebody? So the due process violation claim is frivolous in this criminal defense attorney's humble opinion. It also appears that Mr. Woods claims that the entire conversation was not recorded, and it may in fact be altered and certainly not complete. Now, where this gets a little tricky is that Arizona is a one-party consent state, which means that only one party has to consent to the recording, i.e., it could be the person doing the recording. You don't have to ask the other person. However, the Arizona Ethics Attorney Advisory Committee considers most non-consensual recorded conversations by attorneys to be unethical. All right? Attorneys can record conversations, but you have to get the other party's approval. I would not surreptitiously record a conversation in anything related to my law practice. That is an invitation for big trouble. So if it was in fact Mr. Smith, the attorney in Arizona, and his two clients did this, and he did this, he could have some ethical issues of his own. One of the other issues raised in the motion is that Mark Means wants additional time to file a motion to dismiss, basically to kind of join Chad Daybell's motion that there's not probable cause. That one's going to be heard in early January. Well, the significance of that is that Mark Means waived the preliminary hearing for his attorney, Lori Vallow. He's waived that, so he doesn't get to come back and say, ooh, now I think there's a motion that can be made to dismiss. If you want to challenge that, you have to do it in court. So the defense objects to any of those extensions whatsoever. Now, the affidavit filed by Mr. Woods kind of mirrors the response, basically saying, hey, I've never done anything inappropriate, and court, you be the judge of it. Let's have a hearing on this right away. Now, the prosecution also filed a motion for a protective order. A protective order is simply an order to the party saying you can't do something, all right? And in this particular case, the prosecution says do not let anyone involved in this case, including staff of the court or anybody, release any exhibits or recordings that may have been filed with the court. And this is a little interesting, little nuance to the case, because as you know, Lori Vallow and Chad Daybell, through their counsels, are asking for a change of venue. So you can't basically try and go create a change of venue by creating a circus on your own. You can't do what they call invite air. You can't run off and publish stuff on the internet and then say, Judge, I can't get a fair trial, but you're the one that brought it up. So there's talk that there's a transcript or the recordings are out there. I have been unable to find them as of the filming of this particular episode of Crime Talk. If somebody has a link, let me know. We'll certainly be able to comment. I personally, without having seen what is in a video or an audio recording, I guess I should say audio recording, but based upon what is in the motions filed by the defense and the response filed by the district attorney, I don't think that the defense has met their burden to have the special prosecutor kicked off this case. I just don't see it. And frankly, if there's something on those recordings, guess what? It's ripe for cross-examination if those witnesses are called by the prosecution. Or guess what? The defense, although they never have to present a case, can certainly call witnesses they want if they are in fact relevant. But color me a little suspicious about this motion simply because they didn't put any specifics as to what was allegedly said. Just this broad sweeping allegation of governmental misconduct. I'm telling you, you make that, you start raising the E word, that's right, the ethical word, I'm telling you, you got trouble, and you better be right, because if you're not, the person making those allegations is going to have some ethical conduct issues with their state bar. Let me know what you think. Do you think we should bring in all the clowns yet and the elephants? Because clearly I think we have the start of a 3-ring circus, and I think our ringmaster is going to be Mark Means. In the Lori Vallow and Chad Daybell matter, for those of you who have been following for the last couple of days, if not, catch the videos that we've put up over the last few days. Now, Lori Vallow's attorney, Mark Means, has filed some pretty accusatory motion saying that the prosecutor in this case, Mr. Wood, should be disqualified. He is engaging in all sorts of misconduct. In fact, it even rises to the level of criminal misconduct. Those are pretty bold allegations, and I'm telling you, if you're going to make those allegations, you better be absolutely certain you are right, or guess what? You are going to have the ethical violations coming your way. So, as I've said before, Mark Means does not particularly impress me at anything he's done in these proceedings thus far. The attorney for Mr. Daybell doing a lot better. Mr. Pryor, he did really well at the preliminary hearing. I was a little surprised that he joined in the motion to disqualify the prosecutor because it was rather generic. It didn't give a whole lot of specifics as it related to any of the allegations. So I was a little not impressed by that whole maneuver. Needless to say, the prosecutor responded saying, I've done nothing wrong, done nothing inappropriate, and basically, how dare you call me unethical? And by the way, Judge, I'm so positive that this is ridiculous and frivolous. Let's have a hearing immediately. And oh, by the way, we should have a closed door hearing, and we should also seal all the exhibits that were in fact attached to this motion so that it doesn't prejudice everyone receiving a fair trial. Remember, not only do the defendants get a fair trial, the prosecution gets a fair trial as well. So the court, in fact, did that. The court yesterday issued an order stating that everything will be sealed as it relates to the motion to disqualify the prosecutor. Now, so we're probably not going to get to see any orders on that directly, but we'll see if we get a new entry of appearance from a prosecutor, or if nothing happens, we know that the court shot them down. And as the taping of this hearing, nothing has come about. But there was another filing. Both Lori Vallow and Chad Daybell, through their attorneys, filed a motion for a waiver of speedy trial. When do they have to do that? They have to do that when they're requesting a continuance. As we've talked about before, under the speedy trial clock, Idaho, which is very similar to the one we have here in Colorado, from the date that a defendant says not guilty, the state has 6 months from that date to get them to trial. If the case didn't proceed to trial in 6 months, as of no delay from the defense, the case would be dismissed. I'm telling you, never seen a case dismissed on speedy trial, at least not any in my cases. It's very, very rare. And if the defendant asks for a continuance, you have to say that new 6-month period begins anew, because otherwise every defendant would simply just say, I need a continuance, I need a continuance. You make the defendant waive speedy trial so it doesn't prejudice the prosecution. So we know somewhere along the lines, both Lori Vallow and Chad Daybell are going to be asking for a continuance of the trial date. We'll see if the court grants that. Be very curious to see, and I would love to be a fly on the wall at that hearing today, and I would love to see how the judge handles these allegations that were brought forth by Mr. Means. Now, I did have a subscriber, thank you, we'll just refer to them as C, who sent me a transcript as well as a declaration from the attorney Garrett Smith. The attorney Garrett Smith was the attorney that recorded the conversation that is apparently at issue regarding this motion to disqualify. And this attorney Garrett states in this declaration that he is in fact the attorney for Summer Shiflett, which is defendant Lori Vallow's sister. He goes on to state that he has intimate and personal knowledge of the facts set herein, believes them to be true and correct, that attaches a true and correct transcript of the recording of Mrs. Summer Shiflett conducted by Prosecutor Robert Wood that occurred on October 1st of 2020, that he was personally present for during the discussion. He states that he recorded the interview in its entirety, and then this is where it gets a little weird. He said that he advised Mr. Wood that I would record the conversation because there is going to be communications between law enforcement. And Arizona is a one-party state. As long as one party knows about it, it's probably okay. I think it's unethical for attorneys to do that. So you have to let everybody know that you're recording so there's no issue whatsoever. Surreptitious recording is a very precarious area. We can get lots of people in trouble. So this attorney Garrett Smith, says that immediately upon realizing the gravity of Mr. Wood's comments during the discussion with my client, I contacted Mr. Means to report unprofessional statements made by Mr. Wood and Mr. Means. Now, this is where it gets good. Then immediately upon realizing the gravity of Mr. Wood's comments during the discussion with his client, I contacted Mr. Means to report unprofessional statements made by Mr. Wood about Mr. Means. Mr. Means asked for a copy of the recording. After receiving advice from the Arizona State Bar and with the consent of my clients, I provided the recording to Mr. Means. Now, this is where it gets good. It says that the attached transcript appears to be not an entire transcript of the recording provided Mr. Means, but the first 18 minutes of said recording. So this is where it gets interesting. So all of a sudden now we had these allegations regarding attempting to influence witnesses, blah. I mean, outrageous conduct by the part of Mr. Wood. And what it turns out to be is that there were what the attorney thought were unprofessional statements regarding Mr. Means. And attached is a transcript. Now understand, I'm taking this at face value, and if it is not true and correct, I'll be the first to correct it. I don't know where this affidavit came from, but there is nothing whatsoever in this transcript that I can see that is unethical conduct in any way. There's no way that anyone is threatening witnesses. He is simply explaining what he is doing. He tells them that he's told both attorneys that there are going to be charges coming down. And remember, this interview took place back in October. And he said, I'm trying to make a case for murder, but we're not sure we're going to be able to do that. So this is the part that probably just irked Mr. Means in this conversation. Mr. Wood states, quote, I said this to somebody the other day. Who knows your sister is our goal is. Sometimes you get murder and all you have is that murder and you just have to run out and charge it, and then you kind of put it all together. We were able to put them in jail with a high bail on these low charges and put together a case. Now our goal is to have such a strong case that when she has competent counsel, I don't know if you know this, her attorney has never handled a felony before. Ms. Summer responds, Prosecutor Woods, he's never done any meaningful criminal work at all, and he doesn't know what he's doing. He's a nice guy. Ms. Summer, yeah, I've met him. Other than that, when he's lying about me, but he doesn't know what he's doing. And once we file further charges, she will be appointed counsel who will know what they are doing. And our goal is to put together such a case that they're smart enough to say, gonna be better to talk. Summer, So that's where apparently Mr. Means got a little ruffled around the collar, so to speak. Mr. Woods then goes on and even says, hey, I get it. Everyone's entitled to defense. I've done defense work before he was a prosecutor, done it for 5 years. He understands that there's good people that make mistakes. We'll put this transcript up at ScottReisch.com so you can read it yourself. And I'm telling you, there's nothing inappropriate. Maybe he should have kept his comments about the other counsel to himself, but let's face it, he's saying his opinion. And frankly, it's based upon facts. If Mr. Means has never done a felony trial, jumping in on a serious case where murder charges could be coming down the pike real darn soon, guess what? You may want to have somebody that has done a few criminal cases. But hey, what do I know? I'm just a practicing criminal defense attorney for 25 years. We'll see how things shake out. I think when the orders come out, Mr. Wood remains on the case. Mr. Means is going to look like a fool. And if I'm wrong, I will be the first to say it, but I don't think that I'm going to. So let's wait and see. And hopefully we'll have a new update by the end of the day or over the weekend. But as of right now, nothing regarding the closed hearing that took place today that started at 10 a.m. That's all we have for you today on Crime Talk. I want to thank everyone for watching. You can also go to Instagram, Facebook, and Twitter as well if you would like to check us out. Have a wonderful day. Thanks for watching, and we'll see you next time on Crime Talk.